Good day. I'm Ryan King, one of the senior legal advisors here at CISA Labour.
Good day, my name is Nadine Holland. I'm from CISA Labour, legal advisor.
Nadine, today's topic is one that a lot of companies are facing, and that's how to cut down their staff complement. And that dreaded word, retrenchment, comes to the fore. But before we get there, let's look at what alternatives companies can look at doing in order to try and reduce their staff complement.
Thank you, Ryan. It's true. Look, we can look at casuals. If the company is employing casuals, we can look at casuals. They are normally the employees that are not promised permanent employment, and it's always easier to look at that kind of contracts. Then we can also look at fixed term contracts. Although a fixed term contract has a specific ending date, if the clauses are correct in the contract, both parties can then agree to terminate the contract on consensus. Lastly, there's an alternative that we can also look at as retirement. So if there's employees that have reached the age of retirement now, it's always easier then to just be open with the employees and speak about the retirement age and see if your policy makes provision for that, the contract of employment. Then we can also install that and to reduce the staff.
So casual employees, they work less than 24 hours a month.
Correct.
And there's no contract. These are staff that companies just bring in to try and assist with additional work. But if you're looking at reducing your staff, they're the first ones we look at saying, listen guys, we have to end this relationship and you're no longer required. Is that
Fully
correct?
agree. I fully agree with
And
that.
then entering on to fixed term contracts. Employers need to look at those contracts. They need to look at the termination clauses and ensure that they are ticking all the boxes in terms of that clause before embarking on saying, let's terminate. Because the likelihood is that if that contract was going for 3 years, there was a reasonable expectation for an employee to be paid for 3 years.
Agree.
So it's best to seek legal advice before just simply terminating fixed term contracts.
Exactly. We also need to make sure that the contract is correctly drafted so that it can stand up in a court of law.
Then retirement age. So the clause in the contract of employment dictates what that retirement age is. And again, it comes down to the contractual obligation and how consistent a company is in enforcing that clause. Conversations need to be had with employees that are reaching the age of 65. And they need to be consistent in how they apply that clause in the contract.
Very true, Ryan. Look, companies need to be consistent with all employees, whatever is in the contract. We're looking at whenever there's a clause in the contract, it needs to be across the board. And that's the importance of consistency.
So there's 3 alternatives to reducing staff. Reduction of casual staff, looking at terminating fixed-term contract employees, and then enforcing your retirement age clauses within your contracts. If that hasn't worked, in other words, we're still sitting with too many staff members, what other options do employers have at this moment?
So we can look at other alternatives, short of retrenchments, which we can look at short time. Short time is actually a system where the company reduce the employees' working hours. There should also be an agreement between both parties on the short time, and all employees will then work equal hours. You understand? Alternatively, another alternative, there is layoffs. Again, the employer will consult with the employees on the layoff system. Employees will go home, be at home, be still contracted by the company, but just due to the circumstances of not enough work for everyone, they will be asked to be at home until the company is improving in the business that's coming in production.
So that is a really good alternative, because you don't get rid of key staff members, but you can reduce your capacity whilst you are tendering on a tender or waiting for a project to come in. But in the meantime, there's no work. So you don't have a need for your full staff complement to be at work every day, and then also have the difficulty of having to pay those staff and reduce your costs. So it is a nice alternative for companies that are just sort of waiting for work to come in, and they don't have to retrench their staff. They can just simply enter either into a short time period or a layoff system. When the work comes in, back to normal, full tilt, everybody's back at work, and we run as per normal.
Exactly, and that will also be on no work, no pay, while the employees are at home.
Fantastic.
Okay.
Let's look at now, we've tried all these alternatives, but we still have an issue. The salary bill is still way too high, and companies can no longer afford it, and we have to make an immediate reduction in the staff complement. And we're looking at going into a retrenchment. But before we go into a retrenchment, what can we still do? Any voluntary retrenchments that we can maybe embark on?
Yes, that's also an alternative. We can inform the employees. Look, employees can see that the situation is really drastic in the company. The company needs to consult with the employees and also inform them that, look, this is the way we're going forward. We will have to look at retrenchments. We are in the consultation meeting. They can inform the employees that they are open to voluntary retrenchment. So voluntary retrenchment refers to those employees that feels from their hearts they want to come forward. Some are not interested in the work anymore, or the conditions on how things were going the past few months, or some feel, you know what, I had my fair share at this company, I feel I would rather opt to go. That's an alternative.
And it's a straightforward consultation with one-on-one or with a group of individuals saying, this is the severance package I'm offering. If you want to take it, you just come forward and indicate that you want to apply for voluntary retrenchment. And then the company effectively says, I will accept your voluntary retrenchment and your application. And then the process is concluded in documents. Is
Definitely. Much shorter process going through the long normal procedure of retrenchments.
That hasn't worked. We are now sitting with a scenario where nobody's accepted or offered to take any voluntary packages. We have to then embark on a small-scale retrenchment.
Unfortunately, we don't always wish to go there, but due to circumstances, we need to look at an amicable way that is also beneficial to the employer and the employee. The company cannot keep people employed if they cannot pay them. So we will then look at retrenchments. We get two types. There is the small-scale retrenchments for employers that have less than 50 staff. So the employer will again consult with the employees on the anticipation of retrenchments, inform them, give them time to come forward with any other suggestions or alternative that the company hasn't looked at. Once they've given their input, there will be a consultation between both parties, the employer and the employee party. If they've got a union, will also be present at the consultation. And that would be, in the consultation is normally where we clear out all the important information, for example, whether the company is really suffering financial position, the procedure that is followed, for example, it's last in, first out, or it is through skills that we have selected these employees that are affected. So it is really, and also the severance packages, what the employees will get out of the retrenchment package. So the consultation is just making sure that both parties understand where they are going, and what can they expect from the retrenchment package.
It's important that employers understand that they mustn't just embark on a retrenchment process alone. If they don't understand the process from the beginning, the risk is that the procedure could be at fault, and then it's procedurally unfair, the retrenchment, or substantively unfair, the retrenchment. And that can be quite a costly affair if it's found out later on that there was no rational reason for the retrenchment, and then the company has missed the boat in terms of consultation. That's what often happens as well. So it's important that employers seek professional legal advice before embarking on a retrenchment, and even through the retrenchment.
I cannot agree with you more.
Large-scale retrenchment. Briefly, what constitutes a large-scale retrenchment?
Okay, so large-scale retrenchments, we're looking at employers employing employees more than 50 in the workplace. The important thing here with large-scale is the time frames. So the employer will embark on a retrenchment process of 30 days. And normally, because it's a big retrenchment or a huge amount of employees, the employee party may then request for a facilitator to be appointed. Now, CSR do assist all our clients or employers to facilitate the process of register or going and registering to application for a facilitator at the CCMA or the Bargaining Council. And then obviously there needs to be a consultation, but the whole process is facilitated, and it's just time frame.
So the meaningful message that we want to send out to people is effectively, don't look at doing retrenchments on your own. It's too risky. There's too many specific technicalities within the Act that have to be complied with in order to render that process fair and reasonable. So we would prefer that people would approach us or further legal advisors to come and assist them with embarking on these processes before doing the retrenchment alone.
I fully agree with you.
Good. That's the topic for today.
Thank you.
How to cut down staff. Until next time.